Procedure. Changes of name are either voluntary or done under a condition contained in a will, settlement, or deed of trust. Voluntary changes are not controlled in any way when done by deed poll or Act of Parliament. They are very stringently controlled when by petition and royal license. The stamp duty on a voluntary change is 10s when the instrument is a deed poll, and 10 when it is a royal license. In either case there is an additional stamp duty of 4.0 when the change is made under a will or settlement. It is an utterly anomalous position, which of itself goes far to demonstrate the illegality of the informal and unauthorized methods of change, that unless the terms of the will or settlement specifically require a particular method of change to be adopted, the Chancery Division of the High Court will hold a change of mere motion, evidenced by an advertisement in the press, to be a quite sufficient compliance for the purposes of inheritance. In such a case there is no instrument which can be stamped, and as stamps cannot be collected save upon the actual stamping of an instrument, and cannot be recovered by an action, it follows that change by advertisement avoids this impost. Nor do we see what instrument can be stamped if the change is made by Act of Parliament. Although in this method there are certainly loopholes through which the Crown can make a locus standi to collect the tax. It can, however, often be avoided by anticipation. An heir apparent or expectant, knowing that he must succeed in the future, and on succession make a change in his name, will often find that the circumstances of his case are such, see post, that he is justified in making a voluntary change prior to the date at which it becomes compulsory. The 40 cannot be arbitrarily enforced upon what is an absolutely voluntary change, and the change having been already made, no further act of change is necessary at the date of succession, and consequently there is no further instrument to be stamped. With the exception of the difference in the amount of stamp duty payable, the procedure is the same whether the change be voluntary or otherwise. Before turning to the methods of change, it will perhaps be more in the true sequence if we examine the means to procure necessity of a change. Let us first repeat that the mere expression of a desire that a change be made carries no weight, and may be, as it often is, quite ignored. A condition which is a condition subsequent is not enforceable in the absence of a forfeiture clause. An unqualified command to assume a name, particularly where this is made to include the assumption of a coat of arms, is prima facie bad, and doubtless can be upset if contained in a formal deed. If contained in a will, however, the Cypers doctrine would probably operate, Joyce Cecil v. Joyce Cecil, and reference should be made to the remarks on page 104. Now the chief changes of name, both of the past and of the present time, are changes made in conformity with the will or settlement. The following clause has been modelled on the lines of those which are regarded as precedents, and upon these nearly all clauses requiring the assumption of a name or arms have been modelled, but owing to the loose interpretations of the rules applying to changes of name, we have inserted the manner in which a change can be made compulsory, provided always, and it is hereby agreed and declared, or I hereby declare, that every person who shall under these presents, or this my will, become entitled as, legal or equitable, tenant for life, or tenant in tail, male or entail, by purchase to the possession or receipt of the rents and profits of the where there is a limitation to tenants in common, say, entirety of the, hereditaments hereby settled, devised, other than a married woman, shall within 1 year after he, or she, shall so become entitled where infants may become entitled in possession, add, or being an infant, within 1 year after he, or she, shall attain the age of 21 years, vide infra A, and also that the husband of every female so becoming entitled, not being a peer, or the eldest or only son of a peer, vide infra B, shall, within 1 year after such female shall so become entitled, petition for and endeavour to obtain the license of the Crown, or an Act of Parliament, to enable him, or her, to assume the name of, settler's or testator's name, in lieu of, or in substitution for, such other name or names which he, or she, may have been accustomed to use, vide infra C, unless such person shall already, by rightful inheritance at birth, or by royal license, or Act of Parliament, be rightly authorized to use the said name, and unless in either of the said cases such person shall be prevented from petitioning for the same by death, and if the person so entitled as aforesaid, or, in the case of a married woman, her husband, shall refuse or neglect within such year to petition for, and endeavour to obtain, the license of the Crown, or an Act of Parliament, as hereby required, and fulfil all requirements of such license when so obtained, or shall at any time afterwards disuse or cease to bear such name, or name and arms, in such manner as is before mentioned, then, and in every such case, immediately after the expiration of such year, or such disuser, if the person, or the husband of such person so entitled as aforesaid, shall be a tenant for life, he or she shall, during the remainder of the life of the person so entitled, but without prejudice to the uses, estates or powers, preceding or overriding the estate of the person entitled as aforesaid, and to the uses and estates limited in exercise of such powers, hold the rents and profits of the said premises in trust for the person or persons who would for the time being be entitled to the same, if the person so entitled as aforesaid were dead, and so that in such case all powers annexed to the estate of the person entitled as aforesaid shall cease to be exercisable, and that any appointment previously made by such person, being a married woman, of a rent charge, like for any less interest, to her husband after her death under the power hereinafter contained shall be void, and that the enjoyment of any jointure rent charge previously appointed by such person, being a male, in favour of his wife, or of any portions previously appointed by such person, whether a male or female, in favour of his or her younger children, under the respective powers hereinafter contained, shall not be accelerated, and if the person so entitled as aforesaid shall be a tenant entail, male or entail, by purchase, then the estate entail, male or entail, of such person shall absolutely determine, and the hereditaments hereby settled, devised, shall immediately devolve on the person or persons next in remainder, as if such person were dead without having had issue inheritable under such limitation entail, male or entail. Note A. This may necessitate two changes in the case of a female, once in her own right, and, after marriage, in her husband's right, and if this is not desired, the clause should be altered accordingly. It is advisable to call upon a minor, when a male, to have his name changed immediately upon his estate becoming vested, and a royal license will be granted for a minor upon the petition of his, or her, guardian and good cause being shown. Note B. This exception is special, and should not be put in unless the instructions require it. A peer has a name as much as a commoner, and can be called upon to change it in the same manner. A title has once been changed in a similar manner, but it is not probable that this would be permitted again. Note C. The following clauses should be substituted for the clause in heavy type when instructions regarding the assumption of arms, and C. or other instructions render them necessary, and these will be found to include all possible cases. 1. Petition for and endeavour to obtain the license of the Crown, and C. to enable him, or her, to assume and take the name of in addition to and after such other name or names which he, or she, may have been accustomed to use, the name, testator's or settler's name, being used as the last and principal name. 2. Petition for and endeavour to obtain the license of the Crown, and C. to enable him, or her, to assume and take the name of in addition to such other name or names which he, or she, may have been accustomed to use, his, or her, own name, beneficiaries, being used as the last and principal name. 3. Petition for and endeavour to obtain the license of the Crown, and C. to enable him, or her, to assume and take the name of and to bear the arms of in lieu of and in substitution for the name or names and for the arms which he, or she, has been accustomed to use and bear. 4. Petition for and endeavour to obtain the license of the Crown, and C. to enable him, or her, to assume and take the name of in lieu of and in substitution for the name or names which he or she has been accustomed to use, and to bear the arms of either alone or quarterly with such arms as he or she may be entitled to bear. 5. Petition for and endeavour to obtain the license of the Crown, and C. to enable him, or her, to assume and take the name of in addition to the name or names which he, or she, now uses, the name settler's or testator's name, being used as the last or principal name, and to bear the arms of, settler's or testator's arms, either alone or quarterly with such arms as he, or she, may be entitled to bear. 6. Petition for and endeavor to obtain the license of the Crown, and c. To enable him, or her, to assume and take the name of in addition to the name or names which he, or she, may be accustomed to use, and to bear the arms of either alone or quarterly with such arms as he, or she, may be entitled to bear. The foregoing variations which we have set out at length may seem somewhat superfluous to those legal minds which consider the subject no further than the due and proper or sufficient settlement of the estates, but to those who are versed in the laws and requirements and in the penalties of armory, the necessity of these varying forms to suit the cases which may arise will be readily apparent. Thus, whilst one testator may desire that his name alone shall be borne, and that it shall not be overridden by another name used either before or after it, another testator might be content if he could advisedly rest assured that his name would be perpetuated in some form or another. Again, many testators are indifferent to this subject of armorial bearings, whilst others attach, and rightly attach, importance to the due perpetuation of the arms they have inherited. Considering the expense which is incurred by the procuring of a royal license, and considering also the difficulties frequently attendant upon the proof of the right to the various coats of arms, the advisability may well be questioned of so drawing the clause that a royal license is necessitated thereby as in the precedents which we have given. But we would point out to those who contemplate inserting such clauses in the settlements of their estates, that if they wish to make such clauses and conditions valid and binding, there is no alternative but to make such clauses operative only after the obtaining of a royal license or private act of Parliament, for this reason, that in spite of all the decisions to the effect that the mere unauthorized assumption of a name is sufficient to justify inheritance, when a royal license is not expressly stipulated for, and where no question of the assumption of the arms arises, the fact still remains, as we have already shown, that the assumption of a name of mere motion is an improper assumption, and it is absolutely and admittedly impossible to lawfully assume a coat of arms without the sanction and interference of the Crown. Consequently, if the question of a royal license be ignored, and the assumption of the name be required to be made by a deed poll, the condition is not binding, and may be totally ignored or can be legally avoided, inasmuch as it is arguable, and no doubt on some future occasion will be argued, that no man has the right to assume a name without the license of the Crown, and that no man has the right to procure or require another person to commit or perform an illegal act. The result would be that such a condition had no weight or effect, and consequently the wishes of the testator would remain absolutely inoperative, and the expression of them valueless. Therefore it behooves every man who desires his name and arms to be borne by those who are to follow him, when these future successors are not originally of that name or entitled to those arms, to take care that this clause requiring a royal license or Act of Parliament to be obtained is duly inserted, for by its due insertion, and by this means only, can a man enforce upon his successors the fulfillment of his wishes. There is no clause which has yet been drafted which can be relied upon to attain this object, unless it is stipulated for a royal license or Act of Parliament to be obtained, for the common law will compel no man to deliberately break the accepted and recognized laws and regulations of the Crown. If it be a matter of indifference whether or not one's successors take one's name and arms, there is of course no necessity for such a clause at all of any sort or kind requiring them to do so, but if it be the desire or intention that they must and shall do so, and shall only succeed to one's property on condition of having done so, this end can only be certain of attainment by making the royal license or Act of Parliament absolutely essential. The methods of change of name which are known in practice are, a. Of mere motion, evidenced either by advertisement in the press or by deed poll, by royal license, c. By Act of Parliament. Let us consider them in that order.